You actually got my name exactly right. Thank you.
I'm like 0 or 3 for 3 today. All right, let's
right.
go. Thank you.
Good afternoon. My name is Sarah Nagy. I'm a staff attorney with Columbia Legal Services. We're a civil legal aid organization. We do work on behalf of low-income communities across Washington. And I'm here to speak to you about preventing unfair residential damage claims. What we're seeing is that lack of transparency in these damage claims is leading to housing instability. Inflated or falsified charges against a tenant's security deposit can keep them out of new housing, it can damage their credit, and it can drain their finances in that precarious time between tenancies when they really need them most. Next slide, please. I don't know if I have a, okay, thank you. Just gonna go really quickly through what's in the actual law right now. So, you know, we know what we're talking about when we're seeking changes and improvements. So deposits and fees are treated separately in the RLTA. They have to be disclosed as such in the lease agreement. A deposit is obviously refundable. It has to be kept separate from the landlord's money. The tenant always has to know where that money is being kept, and the tenant's right to that money comes ahead of all creditors to the landlord in case of foreclosure or something similar. In order to deduct from a deposit, the rental agreement has to be in writing. It has to include the conditions under which the deposit can be withheld. At the beginning of the tenancy, the landlord has to provide a written checklist to the tenant describing the condition of the premises at move-in, and at the end, the landlord has to provide a full and specific statement of the basis for keeping the deposit within 21 days, and as the folks on the other panel mentioned, there is in legislation a suggestion to increase that to 30. I'll also add that in current law, the landlord is exempt from liability for delay if things go as far as a dispute in court. They can show that the delay was because of circumstances beyond their control. So that protection currently exists for the landlord. The RLTA makes clear that for the duration of a tenancy, the deposit is the tenant's money and the landlord is its custodian and has to justify their use of it. It's not landlord profit. It's there to reimburse expenses for damage more than ordinary wear and tear. And the landlord has certain transparency obligations, but we're seeing more and more that these are not sufficient to protect tenants as the law is intended to do. A few of those weaknesses, landlords, as we said, can't deduct from the deposit for damages that constitute ordinary wear and tear, but that's not defined in statute currently. So a lot of times renters can be expected to be charged regardless of how carefully they prepare for move out. There's just no consistency in what one landlord sees as ordinary wear and what another landlord does. It's a crapshoot every time, and however well someone prepares for move out, they can still be surprised by these damages that they had no reason to think would count against them. The full and specific basis for withholding the deposit doesn't require documentation of actual costs. So it's very easy for bad actors to exaggerate the cost of supplies or labor. They can simply put down a price on a piece of paper and present it to the tenant as an invoice with nothing behind it. And that's the number there is, regardless of whether that's the actual cost the landlord incurred or not. The landlord also retains the right to send the tenant to collections or report the debt to tenant screening companies or a future landlord, even when those charges aren't substantiated. And that keeps tenants out of future tenancies. The fact of that debt is reason enough to deny someone's housing application, regardless of whether they're working on disputing it, regardless of the circumstances of it, regardless if there's any proof at all that these damages ever really existed, that can still keep someone out of housing. And finally, currently tenants can be sued for debt for damage claims up to 6 years after the end of the tenancy, long after anyone probably remembers what happened, and long after there's been enough time in the unit that there's no way to prove anything anymore. This leads to exaggerated and unfair charges. It's very common. It's very common to see landlords charging every tenant in a building for standard cleaning or unit turnover, regardless of the condition of the unit. Everybody gets that same little deduction. It's basically treating a portion of the deposit as a fee. We've seen charges of hundreds or thousands or sometimes tens of thousands of dollars in excess of the deposit for repairs. It's perfectly possible for a landlord to basically put the cost of a remodel on a tenant and to tell them, we can argue about this or you can go to collections, your choice. Renters, they get surprised by these massive charges. Maybe they really worked hard to clean the place up. They, rented the carpet cleaner. They felt like they knew what they could expect, what they would be charged for. Yeah, okay, my kid scribbled on that wall. I'm sure I'll see something for that, but I did my best to clean up everything else, to clean the holes in the wall and so on. And then they get surprised by these absolutely massive charges or these collections notices. And this is between tenancies when they're trying to pay move-in costs, like another security deposit, first and last month's rent sometimes, and whatever other fees are coming in on top of that. And lacking documentation of actual costs, the more time passes, it becomes impossible to contest. And as I mentioned before, debt to a previous landlord is reason enough to deny someone housing. Increased transparency leads to more stable housing. If we have a clear of ordinary wear, there's greater consistency. Move-out costs are more predictable for both landlords and tenants. Requiring transparency and better documentation than the law currently requires would protect renters from exaggerated and falsified costs. It would help resolve disputes without going to small claims court, and it would help renters discharge bad debt. It's too easy in current law for landlords to charge tenants for costs they aren't responsible for, driving up their housing costs and putting them in a less stable place for future tenancies. And those are ways in which we can hopefully improve those weaknesses in the law. Thanks for your time. Happy to answer any questions.
We'll go ahead and have our second speaker, and then we'll see if we have questions. Go ahead.